Welcome to the Capital Forum's interview series. My name is David Blotner, and we are delighted to have Karen Kazmerzak here with us today. Karen is counsel at Sidley in Austin and previously worked as an attorney for the Bureau of Competition at the FTC. So Karen, I want to talk with you a little bit about one of the interesting things that happened in the past year. The agencies looked at several industries that they've previously investigated for a second or sometimes third or fourth time. And we got some results that were somewhat different than what people may have expected. The first one I wanted to ask you about was the Office Depot, Office Max merger. When the FTC first looked at office superstores back in the 90s, when they considered the Staples Office Depot merger, that was interesting and it may have surprised people back then. Why don't you talk a little bit about what happened in that deal?
Well, just to quickly summarize, the FTC 1997 case was a deal that really was about postage stamps. They defined the market then as the sale of consumable office supplies sold through these office superstores. The FTC ultimately challenged the transaction, and they won in district court. The court found, based largely on company documents and econometric models, that the Staples and other office superstores, which there were only 3 of them at the time, really only looked at each other when pricing their products, and that the pricing of the products, it was local at the time.
Okay. So in the past year, we had Office Depot trying to merge with Office Max, and the FTC had a chance to look at this industry again. So what was the result this time?
Well, they actually defined the market just the same. It was still basically Post-it notes, and the only thing that changed, a couple different things, mainly time. In 1997, yes, there was the internet, but it certainly is not like it is today. Only a few people even were online shopping at the time, and certainly Amazon was not around. Mm-hmm. Fast forward today, Amazon is a perfectly fine place to buy your office supplies. In addition, you have mass merchants like Walmart and Target that you actually see that are trying to compete and do effectively compete. If you look at the company documents in that transaction, I'm sure you would see that Office Depot and Office Max were facing a lot of pricing pressure from mass merchants and internet retailers. And then in addition, all of the various models that were presented to the FTC staff, including the exact same model that they used to win their case in 1997, showed no price effects from this merger.
Okay, so there was no challenge to that merger this time. Let's take a look, if we could, at a market that the FTC has studied before. This is the refinery market in California and the West Coast. Tell us a little bit about how the FTC has viewed that market in the past.
So starting in the 1990s, California instituted certain rigorous regulations for the type of gasoline that could be driven on the roads. The California Air Resources Board, that's CARB, the CARB gasoline requirement ultimately ended up requiring a different type of gasoline than most refineries even make today. And so with that, you had 7 integrated refiners, integrated meaning they have refining operations, but they also market their gasoline through retail gasoline stations. Okay. And with these 7, you had suddenly no capacity in the market besides these 7, very few imports being brought in, and significant entry barriers because they were integrated.
I suppose there were also difficulties trying to put a new refinery on the West Coast.
Yes, you could say that. I mean, you had plenty of refineries out there. It's just what it takes to be able to make this gasoline can be quite challenging. And when you don't have the marketing network to be able to even sell this in California, then it makes it especially difficult to enter.
So what had the FTC done? Had there been attempts by refineries on the West Coast to merge in the past?
There had been, but I think that most of them went in there knowing that they would have to do some sort of divestiture to remedy any sort of issues with the California carb market.
Okay. So in the past year, we had Tesoro, which is a refiner in California, trying to buy a British petroleum refinery, also in California, that happened to be next door to each other. What happened in that situation?
After a lengthy investigation, it was cleared with no divestitures.
And was that a surprise?
I think it's a mixed bag. I think that many found the result to be at first a surprise, but then when you think about it, there were substantial efficiencies to be had here. You have two refineries that are next door to each other and would be operated as a single refinery going forward. And when you have huge cost savings that are potentially significant, they can be passed through to customers. But in addition, you have a very changed circumstance here when you're looking at the California market. When the other transactions required divestitures in the 90s going in through the 2000s, you had an area that was significantly constrained in terms of capacity, refining capacity. With this transaction, there has been a decline, especially with a lot of the fuel efficiency cars, a decline in demand for carb gasoline. In addition, when you look at this merger, yes, BP is selling its refinery in California, but it still has its refinery in Washington State and is still making carb gasoline that could be shipped down to California.
Okay. So essentially you weren't losing a competitor in that market. You still have the same number of competitors.
Correct.
Okay. Imports. Were imports an issue?
What is on the record, it didn't really say that imports were coming from anywhere else. It just, all that was in the closing statement is that there's plenty of excess capacity with the current refineries.
Okay. Well, let's skip ahead and talk about one of the bigger cases that occurred last year, and that's airlines. In the past, DOJ has looked at several airline mergers, and except for the merger involving United and US Air trying to merge at the beginning of the decade in 2000, they had reviewed a number of airline mergers and had not challenged any of them. So what happened this year when American and US Air tried to merge?
Well, they challenged it. I would take issue, though, with your characterization that previous airline mergers had not been challenged, because you do have a few, including Northwest Continental in 2000, where they sued that combination and the parties abandoned. And then you also have United US Airways in 2001 when the DOJ was preparing to sue and ultimately parties abandoned.
Okay. So in the last 5 years, I guess, 5 or 6 years, there have been a number of airline mergers that had not been challenged. So what was different about the US Air American deal?
Well, with the US Air American deal, you have two legacy carriers, and they had significant overlaps. The other issue here is that you suddenly have a market that has consolidated significantly over the last decade, and so you have the potential for coordinated effects. In addition, you have the Advantage Airs. I think it's Advantage Air fares. I can't remember exactly what it is, but US Airways offered certain connecting airfares at a discount, and that was something else that DOJ had issue with.
Okay. So what do you think in terms of the way that case turned out? What do you make of the result in that case?
Well, I know that it has caused a lot of controversy, right? Because ultimately you have this complaint, and it alleges thousands of markets that are going to be harmed. There are coordinated effects, which, as difficult to actually remedy when you're just talking about certain divestitures, and you're seeing consolidation in the market as one of the factors for coordination. But ultimately, I think that this settlement really shows a pragmatic view in terms of the Department of Justice. They were able to ultimately see that the settlement that was offered to them on the eve of trial would remedy substantially all of the harm, the significant harm that they saw that would result as a result from the merger.
Karen, I want to thank you very much for talking with us today. We appreciate it very much.
Great, thanks for having me.